Okay, let's get started. I am recording a makeup class on a unit that consists of rules 115, 116, 117, 2.1, 2.3, because 2.2 no longer exists, and 2.4. These 6 rules are very straightforward. There's not a lot of complexity in the reading. The rules themselves are pretty easy just to discuss in a recorded lecture. So even though the class that I missed was several weeks ago, I decided to do the makeup on this unit because I thought there was the least opportunity cost as far as a foregone lecture. That said, if anything here confuses you or interests you in a more interactive discussion, we could definitely schedule some time for that. Just shoot me an email and I'd be happy to book time to meet with you. So what I'll do now for the next hour and some change is go over these 6 rules and integrate some examples and some relevant stuff from the reading. And I hope that by the end of this slideshow you'll be familiar with these rules to the extent minimally necessary for this class and for practice. That said, if you want more detail, happy to provide it. Okay, so we begin with rule 1.15, which is about the segregation of client funds. Here the basic idea is clients and lawyers are both better off if lawyers carefully compartmentalize their own funds on the one hand from client funds on the other hand. Now, just to be clear, the rule does not insist on rigid compartmentalization among the various clients' funds. Where we really need a wall that no one will cross is between lawyers' funds over here and all clients' funds over here. And there's a very simple solution. State bars have set out this procedure whereby you create one or more bank accounts just for client funds, and if they generate more than a minimum amount of interest, you need to pay some of that interest on trust fund accounts to the state bar. They use it for charitable purposes. Then all of your own money is kept in a separate account, and the thing we want to avoid is co-mingling. That's a bad thing. In fact, even if you are able to commingle your assets with someone else's assets and then take back yours so that there's no harm to the person with whom you shared a bank account, in the world of lawyers, that's still a technical violation. And the reason for this very strict rule is just to create a safeguard, or they call it a prophylactic rule, to make sure no one either mistakenly or worse yet, intentionally, pilfers money out of client trust fund accounts. Now, you might wonder, why would you have client money in advance of earning it? Well, there are a number of reasons. For example, a lot of times lawyers demand prepayment of funds. And part of the thinking is that you collect money in advance of earning it, and then any amount you collected that exceeds what the client owes can just be returned to the client. But on the other hand, if you're representing a client with a very difficult legal challenge, especially a criminal prosecution that may lead to pretrial incarceration, the odds are bad that the client will make more money, beyond what he's paid you initially. And so what lawyers are trying to do in collecting fees that aren't yet accrued is just minimize the risk of non-payment. Also, lawyers might collect settlement proceeds in which several clients, commonly represented by the lawyer, claim an interest. And if those interests conflict, the lawyer has to hold on to the proceeds while we sort out who gets what. So here's the rule that regulates all that. The basic rule is lawyers' funds must be kept separate from clients' funds. Can't be commingled, and separate keeping of funds can be done just with separate bank accounts. That's the cleanest way to do it. Reason for this is to minimize the risk. Lawyers will accidentally or intentionally take clients' funds. And it also keeps you free even from the suspicion you've done that. If you have bank records of deposits and withdrawals, and you can show that all such deposits and withdrawals correlate with client payment of funds and disbursement to clients, then you're good. Bank records are very trustworthy as far as avoiding bar discipline. So one other advantage is we simplify record keeping by the lawyer. If the bank is keeping track of all these transactions, that either could be the lawyer's record keeping or hopefully would backstop the lawyer's separate record keeping. So, Rule 1.15 and state versions of it, because of course all states adopt the ABA model rules. These rules get enforced a fair amount because it's an easy score for the bar. It's sort of like police. Police agencies that need to show, statistics demonstrating enforcement might be tempted to enforce even more vigorously those rules that are kind of easy to enforce. And this may be the easiest to enforce rule in the book, in the sense that there will be very clear financial records that the bank has, whether or not the lawyer wants to divulge them. If the bar can somehow get a hold of the bank records tell the whole story, and so it's a pretty easy stat. I'm not saying that bars would be unscrupulous and just prosecute the easy offenses, but I do think that as between a straightforward violation like this and a much more complex violation, the likelihood is greater that there will be more cases brought under this simple rule. So be careful, because if you look at the back of the bar bulletin, from time to time you see a fair number of these cases. Let's go through the actual language of the rule. So if you look at 1.15 closely, you will see that the major provision we'll focus on here is just segregation of client funds and other property. A lawyer shall hold property of clients or third persons that is in a lawyer's possession in connection with the representation, separate from the lawyer's own property. Funds shall be kept in a separate account, not one per person, but certainly one that is separate, even if it combines many clients' funds from the lawyer's funds, right? It has to be maintained in the state where the lawyer's office is situated or elsewhere with the consent of the client or third person whose money you have. Other property, for example, valuable physical property that may be the subject of a lawsuit, shall be identified as client property and shall be appropriately safeguarded. Safety deposit boxes seem like a smart way to do that. Complete records of such account funds and other property shall be kept by the lawyer and should be preserved for whatever period the bar sets, 5 years in parentheses or brackets, one possible way to do it. States, of course, can pick a different minimum period. Okay, so now what about payment of service charges? So depending on which bank you pick and how much money is in there, there's going to be perhaps some monthly service charges. Banks are really good about charging those. Lately, you sneeze and you pay 35 bucks, right? So banks may very well need to or want to take service charges from the corpus that is in the client's trust fund account. Must the service charges be paid solely by the clients? The answer is no. You, lawyer, without violating the commingling rule, could, if you're feeling generous, or maybe if you feel bad because you screwed up the administration fund, you could pay those service charges, which are likely pretty small. A lawyer may deposit the lawyer's own funds in a client trust account for the sole purpose of paying bank service charges on that account, but only in an amount necessary to pay such charges, otherwise it would be commingling. Prepayment is probably the main reason why you have client money in an account, or I guess so. Prepayment of fees or expenses is governed by 1.15c. A lawyer shall deposit into a client trust account legal fees and expenses that have been paid in advance by the client, so that these funds may be withdrawn by the lawyer only as fees are earned or expenses are incurred. So obviously you have to document that. This rule has a few more equally straightforward provisions. Okay. Rule 1.15d provides that upon receiving funds or other property in which a client or third person has an interest, a lawyer shall promptly notify the client or third person, except as stated in the next rule, or otherwise permitted by law or by agreement with the client. The lawyer has to cough up this money to the client or the other third person to whom the funds are owed. Upon request by the client or third person, that lawyer shall render a full accounting. Obvious stuff, right? This one interests me. I'll tell you, I had an experience representing a pro bono claim, or I should say a combination of survivors of a decedent who died in Pelican Bay State Prison. What I'm about to share is all in a public filing. When I was a pro bono lawyer, we represented a client who had been abused in state prison. This is all information from our publicly filed complaint. But he was an epileptic, and Pelican Bay State Prison is up in near Crescent City in the northern part of the state, and our client was African American. And we brought a suit claiming that racist guards purposefully withheld his medication because they thought it was, I'm not sure exactly why they did it. Our complaint alleged perhaps they were racist or thought it was amusing that he would have epileptic fits. Anyway, I can't mention the settlement amount, but the case was dismissed because we got a settlement. So here's the challenge. We represented a man who had a child, and then the mother of the child, who was not currently the wife of the man we represented, also claimed an interest in the money that we collected, kind of on behalf of the child. And then the parents of the decedent claimed an interest. And our complaint named all of them as survivors. And so it sort of made sense that we should hold on to that money because each sought a bigger percentage, you know, such that the total amount claimed by these various plaintiffs would have exceeded 100%. So this rule provides you have to hold on to the money until you work out an agreement, and in our instance, you know, that required court approval to decide how to divide up the money. Of course, our firm, working pro bono, took nothing, but we had to settle the portion owed to each client. Now, obviously, you don't give that money out in advance. If you do, you know, you're going to run out, and there's probably little likelihood that the clients you overpaid will give back what you paid them. So this rule provides that when, in the course of a representation, a lawyer is in possession of property in which two or more persons, one of whom may be the client, claim interests, the property shall be kept separate by the lawyer until the dispute is resolved. The lawyer, upon resolution of the dispute, shall promptly distribute all portions of the property as to which the interests are not in dispute. You know, hopefully you figure out the dispute so you can clear that account soon altogether. All right, we're on to a slightly harder rule. It's not that hard. It's Rule 1.16. This rule is about declination and withdrawal. So declination is declining to take a case, and you know the short summary is that's very easy. You don't have to take a case. You'll find out in Rule 6.2 if you sign up, say, for the panel in a particular county trying to get appointed to take criminal cases. You're not supposed to duck those cases you asked for. But for the most part, somebody comes to your office, says, I would like you to represent me. The 13th Amendment and other well-settled law protects you from having to work against your will if you've never agreed at any time to represent that client. Now, here's the problem. If you've signed up to represent a client, and so if you're the attorney of record, especially in a pending case, you've entered an appearance, then we call it withdrawal. And withdrawal is actually quite a bit harder because when it involves a case pending before a court, you have to get the tribunal's approval. And even if it doesn't involve a matter before a court, the rules do govern the procedure for withdrawal. So let's get into that. Declination means declining, means turning down a case before you agree to take it. That's pretty easy to do. Withdrawal is getting out of a case after you've agreed to represent somebody. So we have two types of withdrawal. There's mandatory withdrawal. Now what's mandatory is that the lawyer must attempt to withdraw. But if it's a case pending before a court, the judge may not permit you to withdraw. And so what's mandatory is the lawyer trying to get off the case, not the judge releasing the lawyer from the case, which is in the judge's discretion. Permissive withdrawal means a lawyer may, but is not required to, seek to get off the case, just like permissive disclosure under Rule 1.6b was an option, but not a requirement. And once again, the judge has discretion to decline to let the judge or the lawyer withdraw. Okay, so these rules are a touchy subject in Oregon. There was a time, now it's been over a decade, when the Oregon State Legislature decided not to appropriate any additional money until the end of the biennium for the big pot from which indigent defense representation was paid. So to make a long story short, the state just ran out of money to pay for criminal defense in the case when people accused of felonies face prison time, and the Constitution mandated that the state pay for criminal defense. Oregon just said, we ran out. It was 4 months before the end of the biennium. And as the date came closer, when it became clear all the money was going to run out, our legislature then was not really inclined to put more money in there. And there were a few people saying, hey, you know, these are all criminals. Why are we appropriating money for criminals when, you know, we can't even afford to pay for schools? And I think there was a lack of understanding about the constitutional requirement. But the upshot was they had to find a way to patch together representation before the 4-month period in which there was no money ran out. And so for a while there was some talk that lawyers who'd agreed to work on a case would be required by this rule that, you know, most states had adopted, including Oregon. It made it really hard to withdraw. Even if you're not getting paid, with the argument, hey, you signed up to represent a client, and, you know, this was a possibility that the state might run out of money. And so the criminal defense bar, and, you know, their allies, many of which weren't criminal defense attorneys, were outraged by the idea that lawyers who had taken cases initially expecting payment on an hourly basis might have to go 4 months without receiving payment. And then there was even some talk about compelling lawyers to work for free. Now, fortunately, our then Chief Justice, Wally Carson, realized this was really bad for the morale of criminal defense attorneys, and also that it wouldn't be possible to charge more cases. In other words, prosecutors were idle during a period in which there was no money for new, you know, indigent defense cases. So Chief Justice Wally Carson just one day declared, look, you know, money's got to go in this pot. We're not going to compel lawyers to work without pay. If you want to charge defendants in criminal cases, legislature better come up with the money. And that was a pretty smart ultimatum, because the political pressure to continue prosecutions was great. And so the legislature put some more money in the pot. Anyway, that background I mentioned just because withdrawal and the difficulty of withdrawal was quite a touchy subject in Oregon over a decade ago. Okay, so first we're going to explore rules for mandatory declination or withdrawal. When any of these circumstances is present, a lawyer must decline or must attempt to withdraw. So the first would be a situation in which the representation will to a certainty. And you recall, we've discussed the term will in connection with Rule 3.3a, the rule against putting on fraudulent or, you know, deceitful testimony. And the lawyer who knows, not simply speculates, but knows that that information is false, can't put on the testimony unless the witness is, of course, the accused and the lawyer is the criminal defense attorney. But that same degree of certainty we saw when we interpreted the word knows also applies to will. This is not speculation, this is virtual certainty. If you know that this representation will necessarily result in violations of the rules of professional conduct or any other criminal or civil law, you must not take that case. Now we continue. Another ground for mandatory withdrawal is if the lawyer is debilitated, either physically or mentally, such that the lack of capacity or physical strength materially impairs the lawyer's ability to represent the client. If you're already on the case and say you have a stroke, you have to seek to withdraw. Or if you have some great physical impairment and the client comes to you and suggests, hey, I'll pay $100,000 for the following representation, you must decline if you're not physically able to do it. Okay, this one is mandatory. Even though some clients seek to fire lawyers for unreasonable grounds, if a client discharges the lawyer the lawyer must attempt to withdraw. Very easy if the client's paying the lawyer. There's not going to be a lot of second guessing. Clients typically are free to swap out their first lawyer with the second lawyer, even in matters pending before a court. But certainly if it's a matter that doesn't yet have a court case associated with it, there's probably going to be very little trouble swapping out the lawyer. However, if it's the eve of trial, and let's imagine this client has already substituted counsel a few times, the court may not be inclined to let the lawyer off the case, and the court may be frustrated that the client seems to be engaged in a dilatory, that is, delay-seeking tactic. So the court may decline permission. I have watched a number of stern lectures given by judges to clients who want to fire appointed counsel, not so much the first time, but especially the second and third times, when it appears that what the clients don't like is the fact that appointed counsel isn't able to negotiate more favorable terms for a plea deal or negotiate the dismissal of charges. And that may not be the fault of the counsel, it may just be the strength of the case and the government's unwillingness to negotiate. So the court may require a lawyer who has one of these grounds and who seeks to withdraw. The court could still require that lawyer to continue on the case. If the lawyer disagrees with the court's assessment, there's not a lot of recourse. The court can force you to stay on the case. I suppose one could appeal, but for the most part, the judge is the ultimate arbiter of whether these grounds are compelling enough to let you off the case. Permissive withdrawal, as you might imagine, would cover a lot more grounds for withdrawal. And one thing to think about here is probably each of these grounds is less urgent than the ones for mandatory withdrawal, because permission is just for the lawyer to seek withdrawal. The court still has to decide in a case pending before court whether to permit it. So the trickiest issue here is if you want to withdraw after the representation is commenced, always you have permission to decline before you sign on. And just to be clear, I don't know if I went over this, but the point of no return is entering an appearance in court. And that's where you show up with a client at the time of the arraignment, or you show up at the first hearing in a civil case and say, this is Tom Leininger, and today I'm entering an appearance for my client, Bill Smith. If you sign a retainer agreement and say, this is Jennifer Johnson, and today I am, committing to represent Wanda the witness under the following circumstances, and then memorialize in the retainer agreement what the terms of the representation are, that's a contract to represent somebody. So, a bit of a commitment, and so while you may seek to withdraw, it's not so clear the court will allow it. So, bear in mind that without the judge's permission, you're stuck, and so the judge is going to be very attentive to the client's interests. And if the client goes to court supporting your request to withdraw, especially where the court isn't paying for the representation through the Criminal Justice Administration Fund, the court may be inclined to grant it. On the other hand, if the client is kicking and screaming and shouting about betrayal by the lawyer, and the judge is thinking, if I allow substitution of counsel, this case is going to take forever, that's a bad hand of cards. That lawyer may not get off the case. Also bear in mind that the court could force you to stay on it. All right, here are some permissive withdrawal grounds. Longer list. So under 1.6b1, we have sort of catch-all ground for any reason that would support withdrawal and that wouldn't entail a burden on the client. So the court might permit, but at least the lawyer could seek withdrawal if it could be accomplished without material adverse effect on the interests of the client. So basically anything that would be sort of harmless could be proposed. Now, practically it means the client's not fighting you, right? If the client say, I would be grievously harmed, then probably you don't meet this requirement, right? But if the client consents, the court is likely to let you off. Okay, under 1.16b2, a lawyer can seek permission but won't necessarily get it to withdraw. If the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent, Doesn't that seem a lot like the language we saw in 3.3A3 that says that most lawyers can veto client testimony or any witness's testimony if the lawyer reasonably believes that testimony will be false. But you can't do it, of course, for the accused if you're the criminal defense attorney. Now, when I read the words reasonably believes, I think that's a pretty high quantum of suspicion, right? I mean, that seems like more than a hunch. But let's just be clear. Mandatory withdrawal ground is for a lawyer's near certainty that this representation is on a trajectory that it will involve violations of the rule. But the permissive version is just reasonably believing, strongly suspecting, I suppose, is the translation. All right, a lawyer may seek permission to withdraw if the client has used the lawyer's services in the past to perpetrate a crime or fraud. When I first read this a long time ago, I thought, well, that seems so bad. Shouldn't that be a mandatory withdrawal ground? But if you think about it, there's no certainty that the client will continue to use the lawyer's services to perpetrate a crime or fraud. And probably no lawyer wants anywhere near this case once it becomes apparent that a client has used a lawyer's services to perpetrate a crime or fraud. So if the court lets this lawyer off, it's going to be really hard to find the next lawyer. So they make it a permissive withdrawal ground rather than a mandatory withdrawal ground. And some lawyers, I suppose, don't seek to get off the case, although they probably sternly admonish the client. And even one advantage of seeking permission to get off the case is you make a contemporaneous record that you don't support this shady conduct by your client. And that may help you in case you're ever suspected of some complicity. All right, now we get into the interesting ones. 1.16b4 talks about the highly foreseeable situation where your client just stands for principles and has beliefs that offend you. Well, there are a lot of people with bad ideas who need lawyers, and that's not a coincidence, right? Their bad ideas have often led them into criminal troubles or led to various other family conflicts or interpersonal conflicts for which they need lawyers, right? So don't be surprised if at some point in your career you end up with a client whose views are antithetical to your own. Now recall that under 1.2 there was a provision that said, just in case anybody needed the bar's confirmation of this, that merely by representing a client you don't necessarily endorse or manifest your approval of the client's views, right? But even then, a lawyer might find a client's goals to be so obnoxious that the lawyer doesn't want to continue. That becomes a permissive withdrawal ground if the client insists upon action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. It takes a while, but a lot of my friends who experience criminal defense attorneys reach this point where in the abstract they believe that every person, no matter how hate-filled that person is, needs a lawyer. And once you sort of commit to that premise, it becomes easier to represent, the skinhead who threw a brick through a synagogue window or African-American church or something like that. Obviously, virtually every lawyer, I would hope, deplores that heinous activity. And yet, this person has to have a lawyer. And so, I can see why a court, when somebody says, I don't want to work with this person, a court might say, look, who does want to work with such a person, right? And the court might say, you signed up for this panel, and if I give this case to the next person, there may very well be the same objections, right? However, I can also see that if a lawyer felt that he or she were uniquely unable to work with a client, maybe not as well as the next person could, perhaps because the client has views that are anathema to this particular lawyer, or the client has prejudices that may be a particular issue for this lawyer because the lawyer is, make myself the subject of the story. So maybe a client has prejudice against people from rural Southern Oregon, and I'm such a person, right? It's a sophisticated white-collar client. I'm the attorney who is brought on to represent this person. The attorney thinks I'm a hick, which is probably not far from the truth. And the client thinks that I'm a hayseed, I'm unsophisticated, right? And so the client wants a big city lawyer. You know, probably that doesn't bother me until the client stops cooperating because the client has so little trust in me. And now I might think, you know, this client who espouses views and who has objectives for the representation that are disrespectful of my heritage, right? And the story kind of would make more sense if it were based on my religion or my race or anything like that. But it makes it hard to work with that person. Go ahead and use this and see if the court will let you off. Now, even if it's without such, you know, hateful motives, a client who is just uncooperative in some respects might provide the lawyer with a basis to seek to withdraw. So a lawyer could seek permission to withdraw if the client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. This seems like a euphemism for, client's not paying me, I don't want to seem greedy, so there's a, client's not meeting an obligation. But I suppose other obligations might include client is supposed to, you know, provide discovery, right? Client is supposed to meet with investigators, and client, for whatever reason, just will not cooperate with his lawyer, so that the lawyer now is not meeting his or her deadlines to opposing counsel and to the court. If you have such an uncooperative client, that could provide a basis. But I will tell you that if you're trying to get off a case because you are not getting paid, I've seen many times judges say, you know, counsel, that's on you. I can't have my docket slowed down by attorneys who don't make enough of an effort at the outset to collect, in other words, to collect prepayment of expenses in advance of earning those expenses. That's what you do with a client who's facing jail time, maybe a client who's going straight to jail, right? And so, counsel, you have to continue this representation, and you'll learn next time, right? Because this experience will be a memorable one. All right. Under 1.16b6, you can seek to withdraw if there's an unreasonable financial burden on the lawyer or the representation has been rendered unreasonably difficult by the client. Now, this isn't necessarily the client's refusal to pay the firm, which could be covered, I suppose, by either 5 or 6. But think about, I don't know, the book A Civil Action, in which the attorney Jan Schlickman was representing plaintiffs in Woburn, Massachusetts, who were protesting the contamination of groundwater, I think by a tanning plant, or it was kind of owned by Borden Foods, if I remember the exact facts. Anyway, it was an expensive suit, right? And so at one point they had to hire an expert to testify about the extent of groundwater contamination and how it might trace back to this one pollutant as opposed to other polluters and pollutants. And it was going to be very expensive. And I think there's a point where the lawyers in this small firm have to put their own mortgages or take out second mortgages on their houses in order to finance this expensive litigation. And, you know, there's another example. Even if you never expected to get paid, or if the client is meeting the client's obligations, if the representation is unreasonably difficult financially or otherwise, that's a separate ground that kind of overlaps with number 5. Finally, there's a catch-all that says any other grounds could be cognizable as a basis for withdrawal, if the court approves, even if that ground would, you know, maybe portend some harm to the client, if it's good cause, right? So remember, B1 said anytime you can withdraw without harm to the client, then, you know, chances are you get away with that. But B7 is the catch-all where there is harm to the client, but you still have a compelling reason to get off the case. We need this broad provision just in case there's some unforeseen urgent ground for a lawyer to get off the case. So there's some procedures for withdrawal, and as you can imagine, you need to withdraw in a way that wouldn't put any burden on the client. So you have to comply with any statutes, local rules, rules of court, you know, to notify opposing counsel, notify the court, get permission, of course, because local rules may have certain procedures for that, as well as the bar rules. Then your file, your property you've collected, your money you've collected from that client. all must be provided either to the client or to successor counsel promptly, because if you hold on to that for too long, of course, you might cause harm to the client. The withdrawing lawyer has to give the new lawyer all property, exhibits, evidence, obviously physical property that the client has entrusted to the lawyer. Okay, now we're on to sale of the law practice. Law is, in some respects, a business. It's not the same sort of business like a factory where you sell a bunch of equipment and facilities to a buyer when you decide you no longer want to be in the business. But in law, you may very well have built up a reputation, and you may have built up sort of a niche practice within a town. Let's say, for example, I were a lawyer in Eugene doing some really distinctive type of work, like CERCLA cost recovery, that's the Superfund statute, or something really specific about benefits, an area of benefits, like ERISA is a federal statute, or a HIPAA practice which has to do with privacy in medical records, or I don't know. You can imagine these highly specialized practices where over time I'm the person to see in Lane County, Oregon, and maybe I have 3 associates working with me. I may, as I get older, think that it makes sense to sell that practice and signal to my clients. Let's say I have 200 business clients, and I'm the local expert on ERISA, which is a complicated federal statute for employee benefits, right? I may offer to sell my practice, not sell my clients, which sounds wrong, of course. It sounds like you can sell people, and clients are not chattel. But I might say, look, I will sell my practice to a successor lawyer, and basically, write letters to all my clients saying, I've searched far and wide for a worthy successor, and Larry the lawyer or Linda the lawyer is that successor. I believe this person is competent to carry on the practice that I've done here for 20 years. I entrust that person with all my clients. Of course, it depends on the clients, but that endorsement could be valuable. Maybe I could collect $200,000, $500,000 from a buyer if I were to sell a lucrative practice like that. Obviously, there's some real problems here. We don't allow lawyers to sell their practices without restriction. It's kind of an obvious point. But that needs to be regulated, first of all, so we don't create the appearance we're just selling clients, because that's, first of all, just anathema to our notion that we don't buy and sell people. But also, it inverts the normal hierarchy where we expect the clients to be the bosses and the lawyers to be the servants. It would be odd for servants to sell bosses, right? So another problem is that the nature of legal practice is sort of complicated. There's not the same kind of outside scrutiny that there might be from the sale of a simpler facility. I don't know, my dad had a rock crusher to crush big rocks into small rocks. At one point he sold it to somebody else who wanted to crush big rocks into small rocks to make roads, of course. And so it's kind of obvious that you're selling, some land, you're selling some equipment that screens and crushes rocks, but because it's a little more inscrutable in the world of law, it kind of makes sense that the bar itself would regulate the sale of law practices. We do require a lawyer to give up practicing law altogether in an area or give up practicing the same kind of law. So if I sell my ERISA practice here in Eugene, I might have to give up doing any kind of practice in Lane County, Oregon, or perhaps I might just change my practice to an entirely new area of practice, like plaintiffs' civil rights suits that would be very different from ERISA practice, right? But I have to give the purchaser the benefit of the bargain, or it'd be very unfair. And we don't want to allow a fee increase after a sale. Might be, a way to subsidize the acquisition of a law practice, but that puts a burden on the client when the client's getting no value that would justify the burden, right? So it's kind of like what Kozlowski did, remember, in our story about Tyco. He would acquire a company and then lay off a bunch of people to subsidize the acquisition. The purchase of a law firm shouldn't bring harm to the clients. It's not their fault. This one makes a lot of sense to me. You know, a personal injury attorney might have a range of personal injury cases. You know, typically if there are 100 personal injury cases, there are probably 10 that are really promising, that, you know, have slam dunk liability and have a very strong likelihood of recovering big bucks. And then there are probably 10 that are not highly compensable or are hard to prove, or both, right? So you have 10 really good ones, 10 really bad ones, you know, and then in the middle of the spectrum, you have kind of different combinations of probability of prevailing and dollar amount that the attorney could recover. Now, if I'm in the market to buy a law practice, I don't want to buy those 10 good clients, or maybe the top 50 clients, right? Or I should say files, right? But just like insurers are required in certain settings to insure the entire workforce, right? It's like if the University of Oregon is going to go, you know, negotiate for a new insurance contract for all its employees, it probably wouldn't let the insurer sort of cherry pick the healthiest employees, because that would just be unfair. You buy the strong ones and the weak ones, right? So too in selling a law firm, it should be necessary for the buyer to take on all categories of cases within a broad category, right? Otherwise, it'd be unfair. Some clients would never be able to get attorneys, and that just seems unfair. One last consideration to think about is, you know, the lawyer who sells a practice to a buyer is going to transfer some files, right? We could require affirmative consent from clients, or we could just presume their consent if they get notice and do nothing within a certain time period. This may surprise you, but the bar quite sensibly presumes consent from acquiescence, and, you know, if 90 days passes, then the notion is, well, I guess this client is fine with having a new lawyer. The reason why that's so easy to assume is because at any instant, if this client is not happy with the new lawyer, the client can just fire the new lawyer and go get another lawyer, right? So that reduces the risk that the lawyer who buys some files might take advantage of those clients, and, you know, presuming their consent might treat them badly. Those clients will always have the ability to walk away. You might ask, do these rules provide real protection for clients? I think what provides real protection for clients is their ability to walk away no matter who their lawyer is. I'm not sure that these rules, once again, are accomplishing as much protection of clients as they are sort of creating the impression that this transaction is highly scrupulous. In the end, I think, you know, we rely on lawyers to be decent, lawyers to be ethical. I think these rules don't foreclose the possibility of abuse by an attorney who buys a practice, and I think there will always be a risk, but that risk may exist even with an attorney who started to be good and eventually became wicked. That attorney too could abuse clients, so I don't know that the risk is any greater here. All right, so there are 4 conditions. I would just make a list, and if you see any problem on the MPRE or on my exam or in life arise in connection with the sale or acquisition of a law practice, always consider these 4 issues. First, under A, the seller must cease to engage in the private practice of law in this area, right? This geographic area. Now, there's not a really clear sort of radius that you must sort of steer clear of in practicing that area of law. But, you know, I'm going to guess, you know, it's smaller with dense population centers, but it's basically legal markets, right? So the Eugene-Springfield area is kind of one legal market, right? Portland is a distinct legal market. Seattle is definitely a distinct legal market from Portland, right? So I think one who sells a private practice in Portland could then go on to Seattle, and so long as that person is not trying to take back all of her former clients, I think that's, you know, adequate to vacate the area geographically. Or you could stay in the area geographically, but go to an entirely new category of practice. Obviously going from private to government work would suffice, or practicing an entirely new area of law that is different from the practice area that you sold. Here's another requirement. The entire practice, or entire, I should say, area of practice must be sold to one or more lawyers or law firms. We're not going to have sort of relatively unattractive clients twisting in the wind while you sell 90% of your book of business and say, no, you 10%, I couldn't find a home for you, so I'm just selling, you know, the files for the other 90%. Nope, you got to sell the entire group. Sort of like a risk pool of insured people must remain together. Okay, under 1.17c, we have a procedure for basically sending out notice that a practice has been purchased. So the seller probably writes a letter using language that the seller has agreed on with the buyer, and basically says, oh, I searched the earth to find that one lawyer who is uniquely qualified to succeed me. Oh, and did I mention, coincidentally, that's the lawyer who was the highest bidder trying to buy my practice. But anyway, this, you know, when I was a kid with a mouthful of braces, my orthodontist sold his practice to another orthodontist and sent such a letter. It's like, I care so much about my patients. I want to make sure my patients get nothing but the best service. So I went and found the one person worthy to succeed me. And even then, at age 16, I knew, all right, this guy paid the most. I get your puffery, that's what he paid for, right? And then the letter from, you know, departing lawyer to clients also will specify a procedure. Or maybe this letter comes from the new buyer of the firm. Specifies a procedure which probably is, you, client, if you don't like the new regime, just come take your file. And you have that right, and you are not compelled to use me as your attorney. You know, of course, the outgoing attorney recommended me, and if you want to defy his or her recommendation, that's on you. But you're sure free to come take your file. Now, that period can be up to 90 days. After 90 days, we presume that the clients who aren't objecting consent to the assignment of their files to the new lawyer. Like I said before, there's no harm here, because even if the client objects after the 90-day notice period is run, who cares? Any client can always fire any lawyer and take that client's file back. Finally, you can't increase fees to subsidize the sale. So, I mean, is there, or you can't even increase fees for the reason that a practice has just been sold. Is there a magic sort of temporal period within which fee increases are off limits, but beyond which fee increases are fine? No, you know, the legal pro world isn't that clear. I wish it were. I would think, you know, if you're jacking up fees the first, let's say, 6 months after a transaction, that would be highly suspicious. If, on the other hand, you wait a year or more and send letters specifying exactly why fees need to go up. We're in a jurisdiction that has just tripled malpractice insurance rates. We're in a jurisdiction where, I don't know, for, you know, filing fees have just gone up, or, you know, now there's a unique tax on lawyers, whatever. If your letter were to identify circumstances other than, hey, I just bought a practice, I'm short on money, so I'm going to charge all of you more. So long as your letter identifies reasons separate from the transaction as the basis for increasing fees, I think you should be good, especially if you're far away from the period. So a sale that does not meet all 4 of these requirements would not be permissible under Rule 1.17. It's not a multi-factor analysis where they say, oh, 3 are good, 1 is bad. It is a checklist whereby you have to have all 4 of those ingredients before a sale is permissible. Okay, we have 3 rules left in the 2 series. The 2 series is very small by comparison to the 1 series. The 1 series is usually the lion's share of Legal Pro. That's because the Article 1, or the 1 series, is all about lawyers' client-centered duties. And we are a jurisdiction, and the Anglo-American legal tradition more generally is committed to the notion that you know, lawyers are aggressive, partisan, client-centered advocates, right? And their primary duties are to their clients. We've gone over this many times in class. It's just sort of the core tenets of the adversarial system. And so that explains why we have really strict duties to avoid leaking information, to avoid, you know, conflicts of interest. And these client-centered duties that appear in the first rule, or Article 1, I should say, take up, half of Legal Pro, a little more than half of Legal Pro. Whereas the balance of the duties that aren't client-centered get briefer treatment because, frankly, those duties aren't as complicated. They aren't as extensive because they aren't weighed as heavily in many respects as the client-centered duties. All right, so now we're going to talk about the lawyer's counseling role. And this is one where the lawyer is interacting with the client in sort of a low-stakes environment. And so there's no risk of betraying the client. There's no risk of harming the client. This is basically, in Article 2, we start to explore lawyers' roles other than partisan advocacy, which is by far the most common thing we do. So when lawyers are playing more of an advisory role or a counseling role or interacting with third parties on behalf of the client, it's kind of a different drill. And now we're going to have more general standards, right? But let's imagine the lawyer's playing a counseling role, meaning you're in your own office, client comes to visit with you, she's asked for your advice about some options. You are not justifying what client has done in the past, rather you're helping the client in a private conversation consider the full range of options that client might explore. So, because this setting is prospective, not, retrospective, justifying a choice the client made that might have brought a lawsuit, right? Or triggered some objections, right? The prospective time frame, the private setting in which you can have a confidential conversation, that's what really distinguishes the counseling role from the advocacy role we looked at in connection with Article 1. Counseling role is important, it's great. Some of you have shared with me your interest to be environmental compliance consultants or maybe business consultants. And I think what's exciting about that is you're helping to steer the organization. You're not just trying to explain why mistakes made in the past are excusable. You're trying to avoid mistakes and make good choices going forward. I think it's much more akin to management, which is awesome, right? I mean, I think that would be a fun category of work to do. And lawyers who play this role might very well be brought in-house by an organization, whether for-profit or non-profit, and made, a CEO or some sort of corporate officer, right? So counseling role is important to avoid harm to the client. Also, it's interesting, and it might present some opportunities for lawyers to do interesting categories of work and have more important effect on the world. All right, so there's some pitfalls you should worry about when acting as a counselor. The obvious one is that if you push the client too far by assuming the client is going to bend to your will, you might get fired, which is entirely possible. Also, we've talked about how under Rule 1.2d, a lawyer may never counsel a client to engage in an act that's criminal, fraudulent, or in violation of these rules. But a lawyer could talk to a client about whether an action that the client contemplates is unethical for any lawyer to assist with, and that discussion doesn't cause a problem. I think I just want to speed through here. There's some criticisms of the lawyer's counseling role. I think most generally the criticism is that lawyers are sort of toothless in this counseling role. If a client doesn't like the lawyer's advice, there's not really a thing a lawyer can do. And once clients figure out that lawyers must undertake whatever objectives the client specifies, so long as they're not criminal, fraudulent, or unethical, then I think the big peril is the client just will ignore you. All right, so I'm just going to keep moving here. Yeah, let's keep moving. So here's the basic counseling rule. Rule 2.1 calls on lawyers to exercise independent professional judgment and render candid advice. I think in the long run you'll be well served to be an arm's length counselor instead of just a yes person, right? I think a client respects the lawyer who offers an independent perspective. And if you tell a client that a course of action is wrong, client does it anyway, client comes to learn you were right, that client is going to be a big fan of yours and wish that the client had followed your advice. You are not limited to legal matters when you counsel a client. Counsel a client to think about political considerations, moral considerations, economic considerations, supply and demand, right? if appropriate, religious and philosophical and spiritual considerations. If the client's paying and the client will listen to that stuff, you are certainly welcome to bring to bear all of your talents, not just the talents you learned in law school, right? Here's the important thing about 2.1. It does not empower you to sort of blow a whistle if the client defies your counseling. It's not like 1.13. I mean, 1.13, if applicable, would separately provide an avenue for disclosure if the client is engaged in conduct that, maybe this client is in fact a constituent in a corporation and the client is engaged in malfeasance that meets all those requirements. Now you've got a whistleblowing duty. 2.1 though, the counseling rule doesn't provide any new ground for whistleblowing. 1.6b might, 1.13 might, but not 2.1. And so it also does not trump 1.2. That's the fundamental problem with counseling. It only works if you persuade the client. And some clients will just plainly say, look, I don't want to be lobbied. I just want my lawyer to help me accomplish the things that I've decided I want to do. All right, we move on to Rule 2.2. It is a crater where a rule once used to be. What happened is there used to be a rule here that regulated lawyers playing the role of what's called go-betweens or intermediaries. And frankly, we just don't do that. We are more commonly partisans, loyal to just one client, right? Or alternately, we might be third-party neutrals who are neutral as to all people appearing before them, like mediators, arbitrators, etc. So basically, those two scenarios are covered by the 1 series, if we're talking about partisan advocacy, or 2.4, if we're talking about lawyers as third-party neutrals. So we don't need a 2.2 anymore. This is a gap where a rule could go in the future. All right, sometimes lawyers prepare evaluations for use by third parties. This could be, I don't know, let's imagine that 50 years from now, one of you comes back and the University of Oregon is trying to sell this building, right? I mean, maybe in 50 years, I can't imagine it would be outdated, or the U of O would want to get rid of real estate, but for some reason the U of O wants to get rid of this block right here, and part of what's on the block is the Knight Law Center. Perhaps one reason why they want to get rid of it is because there has been some very serious contamination of the site due to a leaky fuel tank. I don't even know if there's a fuel tank on the site. But so your client, the University of Oregon, says, lawyer Lisa, would you please help us to donate this site to, some fraternity or sorority. Or maybe they say, we would like for you to prepare an evaluation so that, some private food seller like Whole Foods might come here and build a grocery store that would be very valuable to students, right? We want to have on-campus food or like a food court or something like that. So what's a little odd about this scenario is that you are working for the seller of the property, but the task assigned to you is preparing an evaluation that a third party will look at. Maybe they're evaluating contamination of the property, or alternately, maybe maybe you're I got women's basketball on the mind because our women's team here is doing so well at the University of Oregon. I hope they're winning today. But let's imagine that there's some professional basketball player and you are trying to work a deal on behalf of one team to basically offload that player in exchange for another player you like more from a different team, right? So you're preparing an evaluation of this athlete who the other team is interested in, and you want to explain that this athlete is not too badly injured, right? It's just a very difficult task in both of those examples, right? Because you're working for the seller, so you have a strong incentive to make it seem like everything's okay. But don't you also have a duty of candor to the acquirer of that athlete or of that property? And so this rule addresses that sort of schizophrenic role you have to play. Basically, the way the rule solves it is by saying, You're loyal to the person who hired you and don't agree to take on such a task. Don't agree to write or give an evaluation for a third-party audience unless you can do so and still be completely loyal to the person who hired you. So under the current version of 2.3, a lawyer may provide an evaluation to someone other than the client, for example, an evaluation of property or an athlete who's transferring teams. The lawyer may not provide such an evaluation unless, quote, the lawyer reasonably believes that making the evaluation is compatible with other aspects of the lawyer's relationship to paying client, like confidentiality requirements, loyalty requirements, conflict-free representation, of course, is always required. So until 2002, all we required was the client's consent. I think the bar is drifting in an even more partisan direction and wants to ensure above all you serve the client well. So now we kind of assume that you're already sort of client focused, and we're only going to require the client's consent if the lawyer knows or reasonably should know that the evaluation is likely to affect the paying client's interests both materially and adversely. So 2.3c says, look, you're not an intermediary, you're not a go-between, you are working for the one that hired you. Or what do they say? Dance with the one that brung you. Rule 2.3c stresses that even when a lawyer is performing an evaluation for use by a third party, the lawyer is still subject to confidentiality requirements vis-a-vis the paying client, except to the extent the disclosure is authorized in connection with the evaluation, or maybe if you have one of the 1.6b permissive disclosure grounds. Last rule. Sometimes lawyers serve as third-party neutrals. This means lawyers acting as mediators, helping parties to resolve a conflict, by consensus, or sometimes lawyers act as arbitrators who would, for example, pursuant to a contract, just work out a non-consensual agreement. I shouldn't say agreement, just arrangement that resolves a dispute, right? So mediation is consensual. Arbitration arises probably from a consensual agreement in the first place, but it's more like a judge just solving a dispute, resolving a dispute. So a lawyer acts as third-party neutral when the lawyer assists two or more persons who are not clients of the lawyer to reach a resolution of a dispute or other matter that has arisen between them. Now, what this rule is at the present time is more of a placeholder. It doesn't really have a lot of regulation. That's really due to two reasons. First of all, the field is very new, and we're not exactly sure what sort of regulation would be appropriate, because this stuff like mediation and arbitration and a wide range of things like charrettes and ombuds work and all that, this kind of work is alternative dispute resolution, or some people say appropriate dispute resolution, but for it to be the alternative, it needs to be more flexible. It needs to be less regimented. And so one of the problems with prescribing these ethical rules is it might stultify the field, which is supposed to be the alternative, and make it too routinized and too inflexible to serve the function that it ought to serve as the alternative to this protocol in the court system. All right, so another problem is we, as lawyers, are only a subset of all the practitioners of ADR, right? Many of them may very well be, leaders of religious organizations or community organizers, right? And just wise people who don't have law degrees. And if we had too much regulation under 2.4 that uniquely applies to lawyers who are trying to get some of this business, we might put lawyers at a competitive disadvantage, because the other practitioners in this area who aren't lawyers wouldn't be subject to those rules. And so I guess part of the thinking was, at this early stage in the development of ADR, we shouldn't put unique burdens on lawyers. And of course, one big part of the motive for writing any rule is, trying to create a livable world for lawyers, because these rules are written originally by lawyers. Okay, we've talked about common examples, arbitrators and mediators. I did mention that there's this type of arbitration we talked about briefly in 1.12, and that's the conflicts rules for third-party neutrals and judges. But We talked about multi-panel arbitration, or arbitration where basically a single panel consists of members that are drawn from sort of partisan affiliation. So imagine, like, I don't know, a union dispute where we bring in one member of this group who's sent on behalf of the employer, one member of this group that's sent on behalf of the union, one member that's sent on behalf of, say, the University of Oregon. Like, the student's kind of a third party that's got an important view. These three are not truly neutral, right? These three are sort of sent on behalf of constituencies, so we wouldn't call them neutrals. But third-party neutrals would mean the people who don't have any ties to any of the parties that appear before them. So all this rule says now is that a lawyer who is acting as a third-party neutral must take care to make sure that everyone who appears before him or her understands that our lawyer is only acting as a third-party neutral and is not the lawyer, the conventional partisan lawyer for that particular person, right? That's all we have to do now. I could imagine a day, you know, if you're in practice for 10 years and you suddenly veer into third-party neutral practice, you might want to check 2.4 again. It may one day have more rules, but not so far. I think the bar doesn't want to get ahead of regulations that the mediation profession or the third-party neutral profession as a whole might develop. Okay, that's the end of this slideshow. Let me say again, if you would like to meet with me about anything that's discussed in the slideshow or about any aspect of class, just send me an email, mention 3 times you can meet, and I'm optimistic we can work out a time to meet.